Howdy, everybody. We're talking about Texas Rule of Evidence 503 today. It's about attorney client privilege. This is one of the rules that I think regular people have heard about. If you're not a lawyer, you really don't know a whole lot of the rules of evidence. I think most people aren't even looking unless they're got like a trial coming up and they're representing themselves. If that's what's going on, don't use this video to help you out with this. Go get an attorney. Get yourself some attorney-client privilege. Anyway, attorney-client privilege is under Texas Rule of Evidence 503, and it discusses what a client is because a client isn't just a single individual. It could be a public officer, it could be a corporation, an association, or other organization. You can even have cases in civil law where you might have one lawyer representing the CEO and another lawyer representing the company or the organization itself because the CEO has somehow wronged the organization in their fiduciary duty. So we have to see if you are looking to see if you have attorney-client privilege, you have to have an attorney-client relationship. And it's not true that every time there's not an attorney client relationship, you don't have privilege. So, for example, I'm a criminal defense attorney. Every person that calls me on the phone, everything they say to me is totally confidential. If my staff sends them a letter of engagement asking, if they want to become a client, and then they decide, I'm going to go with somebody else or I'm going to represent myself, bad idea. But in any case, if that happens, it's not like we lose attorney client privilege for the conversation we had. We just haven't formed an attorney-client relationship. So until everything's formalized, we receive payment of the attorney fees and the signed engagement letter. We haven't formed a full attorney-client relationship, but everything that was said to us is privileged, and that's a special rule, especially for criminal prosecutions. We'll get to that here in a minute. But if you render any kind of professional legal services by a lawyer or you consult with a lawyer, then that is going to be covered under attorney-client privilege. You may be asking yourself, after the end of this video, since you're a lawyer, Brian, do we now have attorney-client privilege? Well, these videos are not legal services that we're rendering. It's just educational. And so no attorney-client relationship is formed because you watched a video, and there's no privilege if you were to type something in the comments. So keep the privileged stuff you don't want people to know out of the comments. But keep your the comments coming so that other people can learn. And if you have a great question, put it down there and we'll answer it in the next video. So here's the language of the rule specifically for criminal cases. It says, in a criminal case, a client has a privilege to prevent a lawyer or a lawyer's representative, which is like the staff members of the office, from disclosing any other fact that came to the knowledge of the lawyer or the lawyer's representative by reason of the attorney-client relationship. So in a criminal case, what people always want to know is well, how much can I tell you? The answer is everything. You can tell a criminal lawyer who you are seeking a consultation from, or is your criminal lawyer, everything. There's a rule that even says if you were kill somebody and tell your lawyer where the body is, that lawyer can never tell anybody, even after you die, even if there's no other issue there, because you're a state, an executor of your estate, anybody can assert attorney-client privilege for you that has an interest. It's not anybody, but it's close to anybody. But that is how far the criminal attorney-client privilege goes. And the reason for that is so that we can effectively help our clients. If we don't know what the truth is from our client's perspective, then we can't understand what's a good deal, what's a bad deal for them, what's the best defense going to be, what's not going to work out, what is going to work out. We have a duty not to sponsor false testimony as well. So there's some ethical considerations. We may have a series on the ethics rules as well. So if there's an issue where we think a client is going to testify falsely, then basically you have to withdraw from representation, or there's an instance where you can allow testimony in the narrative if you're not sure that false testimony is going to happen, but you believe it could be. Basically, a lawyer cannot sponsor false testimony. But in any case, you should always tell your criminal defense lawyer the truth, the whole truth, and nothing but the truth, because that is going to enable them to help you the best. And then the last part of Rule 503 I think is important to know about is work product. And this is stuff that your attorney writes or makes for you. This is also covered by attorney-client privilege. Attorney work product privilege belongs to the attorney, though. And this includes documents, reports, communications, memoranda, mental impressions, conclusions, opinions, and legal theories prepared and assembled in actual anticipation of litigation or for trial. And so this is stuff that, like, if you are writing down what you're going to make as your closing argument in a case, before you go to trial, the state can't force you to give that up. That's attorney work product, and the attorney can keep it.